Alrighty, I'm going to go ahead and pin your video and give you the go ahead. Thank you, Lori, for being here.
My pleasure, Jackie. Hi, everybody. It's our last session of Legal Matters, and I'm really excited to go over the content for today. It's a content topic that I get a lot of questions about. So I anticipate that you'll have questions for me. So please feel free to ask those in the chat, like Jackie said, or in the Q&A. And I'm also open to questions that you may have from the previous 3 sessions. I know we've been going over a lot of content and you've been doing your self-audit on your audit sheets. So if there has been any questions that have come up while you've been doing those, this would be the time, since it's our last session, for you to ask those. All right, so let's go ahead and jump in for today's content. Again, our whole point here is to build a stronger business. As Jackie said, my name is Laurie Lee. For the past 17 years, I've been a business attorney. I've helped hundreds of small businesses and building their legal infrastructure, putting things in place to avoid problems, putting things in place to minimize problems when they do occur, and then putting things in place to build value in their business. And so this last piece, building value in your business, is what we're going to be talking quite a bit about today with intellectual property. So before we jump into today's, let's take a quick review. And I do this every time because I want you all to understand yourselves as a business owner. I want you to understand where you sit on how you make decisions. So we're going to go over it again today in the flyers and the grounders. Again, if you are a flyer, that means you jump off the cliff and you try to learn to fly as you're building your plane. And you're trying to figure it out as you go, and you just take things one thing at a time as it comes in front of you. If you're a flyer, that means that you probably haven't figured everything out yet, and that there's a lot of holes in your plane, as this picture shows, and it's time for you to circle back and start plugging those holes and figuring out those things you may have overlooked in the midst of trying to address the most immediate things that happen when you're starting a business from the ground up. The grounders, on the other hand, are those of you who get to the sky by growing your tree nice and strong, and you start off wanting to know everything and doing all your research up front before you take action. So, and the grounders, you guys are here and wanting to learn things before you take those steps. And both types of business owners are legitimate. Both types are successful. One is not better than the other. So for all you flyers out there and you grounders, it is perfectly acceptable for you to be that way. You just need to know where you sit on this. So especially for the flyers, that you know that you come back and get this information and start building this infrastructure into your business. And for the grounders, that you know that you are getting information that you can take the next step. So there's pros and cons to both ways, and there's no judgment here. Again, our clients are both kinds. So just so you know where you sit. In both cases, you need to build a stronger plane. You need to make sure that your business is strong enough to sustain additional clients that you bring on, or additional customers as your business grows, additional workers, whether that's employees, independent contractors. The more people you put on the plane, the more business you put on the plane, the heavier the plane gets. And to continue to grow and gain altitude, you need to build a stronger plane. So that's what this is all about, is building more legal infrastructure into your business. And we've been working off of this infrastructure map that we have. Again, just as a reminder, this is for service businesses because our firm, the legal department, is solely serving service businesses, small service businesses. So our clients are less than 20 employees, and they provide services. Most of them are professional services, licensed, educated, regulated, but we've got all kinds of services. Some are not, with a college degree. Some of them don't have licenses. Whatever that is, if it's a specialized service, that's what this map is for. So we've already gone over government regulations. That was our first class for legal matters, and we went over those 2 types: entity structure and regulatory compliance. I hope you've got your audit sheets put together for those, and you know where your holes are that you need to calendar and go back and address those issues. The second class, we covered external relationships, and we covered client relationships, the importance of having a good client contract in place, and then vendor relationships, understanding the contracts that are given to you by your vendors, and reading those and making sure that you understand those. Then we talked about, last week, we talked about internal relationships, and we talked about relationships with business owners, as amongst themselves. The ownership of the business is very tricky. We talked about the default rules and how to change the default rules for business partners. And we also talked about workers, whether those are employees or independent contractors. And you went through and did your audit sheets on all of those relationships that you have with those people. And hopefully that will have given you some light bulb aha moments of things that you need to go back into with your business and maybe put some infrastructure in place. So that leaves us with today. Today is our last topic, and that is what you create. And that is all about intellectual property. And we're going to be talking about 3 types of intellectual property today and how all of that functions. So focusing on today's intellectual property, I will tell you this is probably the most confusing area of law that small businesses get themselves tripped up on. There's so much information online that people tend to do the research and they may not come up with good answers. So today we're going to go over exactly what these things are, give you the information that you need for this. You will also have an audit sheet for this as well. So this will be your last audit sheet to do for your self-assessment. Okay, so what you create. I first want to divide your creations into 2 categories. The first category is what you create for your own business, internal usage. I know this might be like, what? You do create intellectual property inside your business that your clients or customers never see. And that is very valuable. It could be things, and we'll talk about a little bit more of this, it could be things just a matter of checklists. As you can probably tell from being with me for the past 3 weeks, I love checklists. I love lists of any kind, to-do lists, assessments. So my firm, we have a lot of checklists. We have checklists for all the different types of contracts that we write. We have checklists for all the things that we file and do with the government and with licensing. All of these things that we create, our clients never see them. Our clients never see our internal checklists, but they are really important and valuable to my firm. If I gave all of my checklists, all of my internal things that we've created, if I gave that to another law firm, it would make their lives so much easier. It would make everything go like this. And that's an advantage I would give to them. And if they compete with me, if we practice the same type of law with the same type of clients, then I'm giving my competitor an advantage by sharing my intellectual property with them. So think about what you create in your business that is completely internal. It doesn't go anywhere. It's not shared with anybody outside your business. And that is also intellectual property. Because if your competitor were to have that, it would give them an advantage. It would give them some sort of benefit. So keep that in mind as we go through, because most people think about intellectual property in terms of what you create for your clients. And this is the second category. This is the thing we mostly think about. So it's what do you create that you're selling? And maybe some of you sell a product, a physical product that sits on a shelf or is delivered in some physical format. And some of you may not be product-based. Some of you might be service-based. So you don't really sell a product that people can touch, but you sell a service. And believe it or not, services also have a lot of intellectual property that they create for their clients. And so we're going to talk a little bit about both of these kinds of intellectual property for our class today. All right, so let's talk about what you create for your clients. Here's some ideas. Maybe it could be custom products, maybe something that your client or customer comes to you and says, I would like for you to make t-shirts that have my business name on them, or my logo, or my slogan, or maybe I want you to create something specifically for me. So it might not be something that you create and mass produce the same thing over and over and over and over again, and you sell the same thing over and over and over and over again. That's one thing. This is something different. This is maybe for those of you who do custom work. So it's different. What you create is different for each client. That's what we do, right? We're a law firm. We don't give the same contract to every single client that walks through the door. When we draft contracts, they are customized for our clients. So it could be something where you either do a product or a custom service for people. What else might you do? You might draw, create, design things. Maybe you don't produce it, but maybe you design it. Maybe they're logos or graphics or some sort of images, photography. You know, we've got so many clients that are in the creative fields, and they have music, they have photography, there's so many different, we've got marketing agencies as clients that create all kinds of things. They create blog posts and articles and social media posts, and they create slogans and graphics and branding, and they're doing all of this for their clients. And so it might be things that you create, but you don't necessarily produce. You just create it. That could be part of the intellectual property. What else? You could do drawings. Maybe so for our architects and our interior designers, you know, they're creating drawings and they're sketches for people, and they have these, you know, it's maybe a collaboration, a combination of clients coming in and saying, this is what I want, and then the architect puts it together, and maybe it's the engineer firms who are putting together some of these drawings and documents and supports and formulas, or it could very well be a matter of you know, putting together a way for somebody to do something. It could be very simple, just a simple drawing. That could be intellectual property. And it could be products, like this was just jewelry, so custom designs. So if, you know, for jewelry designers, there could be some things that they create custom for their clients, and then there could be things that they create over and over again that goes into their shop. All of these things are part of intellectual property. Again, it doesn't necessarily have to be on paper. And the reason I put this one on here is because it can be electronic. It can be things that are never printed out, but are electronically documented. And so when we talk about intellectual property, start thinking a little bit bigger than what you had probably thought about previously. You may have just thought about a book as being copyright, or a photograph, or a logo that's been trademarked, or a product that has a patent. Yes, all of those things are intellectual property, but I want you to think broader than that. I want you to expand what you think about when you think about intellectual property, your intellectual property in your business. And so these are the things that you're going to start making some notes about as you go through the next few months in your business, to start documenting what is in your business that could be your intellectual property. And if you have some ideas right now as we're going through, I want you to take some notes on those. Go ahead and jot down what you come up with. Because I'll tell you, the audit sheets that you do is part of our intellectual property. If you'll notice, there's a copyright at the bottom. We claim our copyright on that. So it could be anything that you create. Start taking some notes as ideas come to you. And again, it doesn't necessarily have to be paper. It could be something that is electronic. But I will say something right now, and I think this is really important to understand. Ideas are not intellectual property. Ideas in your mind, ideas that you speak and share with people are not protected. And the reason for that is, if we were to allow people to hoard ideas or claim ideas, and then that person never does anything with the idea, then that idea is basically locked up forever, and no one else can take that idea and run with it and actually take action and do something with that idea. Now, if we were to allow ideas to be locked up and hoarded, and that person never does anything with it, that's not encouraging creativity. It's not encouraging the expansion of the market. It's not encouraging new things coming into our society. So the law says, no, we're not going to protect ideas. You can have as many ideas as you want to, but they are not going to protect your ideas. It will protect them once you put them in physical format, and they call it tangible format. So once you start putting them into drawings, into action, that's when it starts to become protected. So if you want to protect an idea, take the next steps, put it into place, and then take the steps that you need to protect that idea. And so one of the things that I want to talk to you about today is the ability to protect that intellectual property. So once you've taken the action, how do you then protect it? So we're going to talk about the actions to take and then the protections for them. All right, so let's start with our first, oh, there's one more slide here. So again, these are drawings, workflows. So sometimes with patents, we've got the ability to document how things happen, a process. So we'll talk a little bit about how that works a little bit later. So processes, checklists, manuals, all of these things are different types of intellectual property. So there's three types, and we've talked about the three types already a little bit. Is you've got patents. Patents are for actual physical products. So they are things that you manufacture or produce. So service providers like our clients don't deal with patents because service providers typically don't produce or manufacture a product. So for those companies that do manufacture products or design products, patents could be a possibility for you. And most every business will deal with copyrights. So we'll talk about copyrights. Copyrights are very broad. It is the most common kind of intellectual property. And it's the easiest to do. It's the easiest to protect. And then you've got trademarks, which we'll talk about also today. We'll talk probably a little bit more about trademarks than the others, just because that's where I usually get the most questions as to how trademarks work, what the different types are, how to register them. So we'll go over some of that today. But first, I do want to start with patents. And I will tell you right now, I am not going to get very deep into patents. Patents are so complicated that there's specialty lawyers who just do patents. And there's a reason why they require a specialty lawyer to do them. is because they're very complicated. So I am not a patent attorney. There are patent attorneys. So if you want a patent, you have to go to a specific type of attorney, and they have a specific bar exam. So most of you understand that as attorneys, we take a bar exam. So once we take that bar exam, we are practicing attorneys. Patent attorneys have to take another bar exam. It's the patent bar, and they have to pass science. It's a lot of science and it's a lot of math. So not every attorney can take the patent bar. You have to either have an undergraduate degree in a science field, and they're set out. So like biology, chemistry, physics. So you have to have an undergraduate degree in one of these listed sciences, or you have to have enough class or course credit. So if I'm an attorney now and I want to go and do patent law, I have to go back and take a bunch of science courses in college and undergraduate in order to be able to take the test to be a patent attorney. So that tells you, the reason I say this to you is because I want to stress to you how much it is science-based, very much science and math-based. So it is all about documenting the scientific process that is involved in making a product. So what is the definition of a patent? A patent, once you have it and you go through it, it is the right that is granted to an inventor that allows them to exclude all others from making, using, or selling their invention for 20 years. So that is the definition of a patent. So I'll say it again. It's the right that an inventor gets, and they can exclude, prevent others from making, using, or selling their invention for 20 years. That is a patent. That is the point of the patent, is that you are the exclusive provider of that invention. And again, it is an invention. So it has to be something new. So the first person to get the patent is the only person that can get it. And it has to be something new. So people can't go in and get a patent for, what's something that we all know and it's been around forever, something that it's common. No one's gotten a patent on it. So, but you still can't race in and grab the patent for it because it's not something new. It has to be in a new invention. It's a physical thing, so you're producing a physical thing. It is through the United States Patent and Trademark Office, the USPTO. There is a very lengthy application process. So there's deadlines for it. And one of the things that I want to mention is once a patent is in the public, once a invention is in the public, your time for filing an application is normally done. Like you've missed the deadline. So one of the things that's really important for patent work is that you don't disclose the invention before you file your application. So you typically, and there's general rules for everything, and you understand that the general rules, and then there's always these exceptions out here. I'm talking the general rules. The general rule is that once you put it out there in the market, once you start selling it, once you start disclosing it and making it public, you can no longer apply for a patent. So you do it before you put it out into the public, before you put it out into the marketplace. Typically, that's the general rule. So timing is really important for patents, and one of the things that people get tripped up on. So a lot of times you'll see people who have developed a product or an invention, they'll use non-disclosure agreements, NDAs. So they'll use an NDA to talk to the manufacturer that they're going to hire to manufacture their product, or they'll use NDAs when they talk to people so that they're keeping it under wraps so that they don't blow their ability to file for the patent. That is the extent of what I'm going to say about patents, because if I go too much into more detail, I'm going to start running into a lot of exceptions to the rule. So what I would say for you is, what I want you to understand is it's very scientific. You need to have a specialized attorney to help you through it. It is not just your friend who went to law school. It is somebody who has to be patent barred. They have to understand the science behind it and to be able to translate what you're doing into scientific language so that that can be put onto the patent. I know there's been a lot of circumstances that I've seen over the past 17 years of practice that, when sometimes people try to do the patent application themselves and they don't word it the way it needs to be worded. They don't cover the whole field. They don't blanket everything, so that when they describe it, they only describe this part of it. They don't describe it broad enough. And so there's room for other people to come in and start doing something similar. And then like, well, wait a minute, I thought I had a patent. Well, you do, but you only have a patent for this, where you could have had a patent for this, but you didn't word it correctly. So just keep that in mind if patent is on your radar. The next one is copyrights. And like I said, this is the most common for business. The businesses have more copyrights than they have usually of anything else. And copyrights, especially for our clients, I should say for our clients, because our clients are service providers. And so we do a lot of creating. We do a lot of creating of all different types of things. And so for copyrights, and it's one of those things, let's talk about the definition and then I'll get into a little bit of detail. So copyright is the protection given to the creator of a creation that is in a tangible medium of expression. In other words, it must be set out for people to see and not just an idea. So let's break this down, because copyright is so broad. It is creation is, anything basically. So it's the creator who owns it. First of all, the person who creates it owns it. And that is the general rule. So once they create the creation, they own it, and it has to be in a tangible medium of expression. And this is what I was talking to you about earlier, is that you can't just have an idea in your head. And so people need to be able to see what you're saying. There are copyrights for hearing as well, like musical recordings and things like that. But there's a whole lot more rules that go into that kind of a copyright. And most of us in business don't have the auditory type of copyright. We have some sort of visual. So that's the definition of copyright. And there are two types of copyrights. There is a common law copyright, which just means that you have the copyright as soon as you create it. As soon as you put it into a tangible medium of expression, it is yours. The copyright belongs to you. No one else can take it. There are some problems with that, as you can probably imagine, because you'll have to prove it. You have to prove that that is your copyright, that you were the creator and that you created it before someone else created it, and all of that. So it is instantaneous. You don't have to do anything. You don't have to file anything. You have to do nothing. As soon as you create it, you own the copyright to it. But it's not as great of a right as you might think it would be, because again, you have some proof issues. So the second type of copyright is a registered copyright. And this is through the US Copyright Office. So this is where you see books being submitted for copyright. You see sometimes articles and all kinds of things are submitted to the US Copyright Office. Sometimes even paintings are submitted to the US Copyright Office. It's really interesting to go and see. If you have some time and you're interested in this, the US Copyright Office is a great website for you to just look around and see what's there. They've got some great resources there. It can be a little confusing because, like I said, we're talking general rules here. And so there's a lot of exceptions and a lot of spin-offs of really specific types of copyrights. So it can be, it can feel like you're diving into an ocean of complication. But just, back yourself out and understand that there's two types of copyrights. the one you get instantaneously, and then the one that you have to register for. And so then once you have your copyrights, how do you use them? In business, we do a lot of licensing of copyrights. So it's, you create something, and remember we talked about the two types. There's the type that you create inside your business for your own use. This just stays here. You don't really have to do anything with it. But then the type of copyright that you create for other people, whether you sell it or whether you allow other people to use it, that's when licenses come in. So if you're keeping the ownership, but you're just letting people use it, that's a license. So you have the rules. Yes, you can use it as long as you pay me, as long as you don't destroy it, as long as you don't claim ownership of it, as long as you don't try to, all kinds of things for it. So that's the license. The assignment is when you sell it. Like you say, I am giving up ownership of it, and I am now transferring ownership to you. And that's different than a license. A license means you keep ownership. An assignment means you're giving up ownership. And so for copyrights in business, that's typically what we deal with most, is licenses and assignments. And it's very, very important that all of this be in writing. So I will tell you, no matter what end you're on, whether you're on the giving end or whether you're on the receiving end, all of it has to be in writing, because the law is very specific on this type of area, this type of intellectual property. Because it says it's pretty easy when you're dealing with real estate or you're dealing with things that you can feel and touch and have. When you're dealing with intellectual property, there's not a lot of evidence. It's very intangible. And so the law steps in and says, we need documentation for all of these things. And so if you don't have the documentation, it's like it didn't exist. So it's very, very important that these things come into documents, like that you actually get them in writing and signed. So that's important for that. So that's copyrights. I will give you a little bit of a tip here on common law copyrights. So let's talk about for common law. If you want to claim your copyright, common law copyright, you can do this very easily if you put a copyright notice on your tangible mediums of expression, whatever those might be. So for us, this is what you would see on some of the things that we create that we have copyrights for. It's the C with the circle around it. It is the year that you are claiming your copyright, and then it is the full legal name of the owner. Now, I could have my name right here. I could have Laurie Morgan Lee as the owner, but I'm in business, and so my business is what owns that copyright when we put on things. So depending, and I do have clients that are artists and all kinds of other situations where maybe they own the copyright instead of their business. But whoever owns it is the one that goes on this copyright notice right here. And that's important, because what that does is it says to anyone who sees it, it says, this is owned by this person, and this was when it was created. So the first time it's created is really what you use here for this, because if someone else claims that they created it before you, they're going to look to see what this date was. So I know we're getting kind of technical on this one, and I know we're getting more in the weeds than we have in the past few weeks. But I'm doing it because these are some of the questions that I typically get with copyrights, especially, and with trademarks, which we'll talk about next. So if this feels like it's not part of your area, that's okay that you just kind of glaze over on this. But if this is something that has been important to you, then this is something to keep in mind, to make sure you put your copyright notices on whatever it is that you've got. And it will at least help a little bit with some of the evidentiary things that you might have to overcome to prove that that was yours. Okay, I'm going to just pause for a minute and pull up the questions. If I have any questions, let's see. I have one question. I'm going to read it to you guys. Before I move on to trademarks, we have a question here on copyright. It says, I learned on the U.S. copyright site, Circular 41, that copyright law does not protect interior design, but does protect architecture. As an interior designer, is there anything that I could copyright, such as my digital presentations? The answer is yes. There are still things you can copyright. And this is one of the things that I just talked about when you go to the website for the U.S. Copyright Office. You can get into really technical details. So this is a profession that is interior design is one that is goes a little bit deeper and has a little bit more exceptions to it for the copyright. So it would be a matter of, for your particular profession, and some other of you might have some profession specific rules for copyrights. So when it says interior design, keep in mind that that's not talking about your digital presentations. So this presentation that I'm giving to you right now is my copyright. Whether I'm a lawyer, whether I'm a doctor, whether I'm an architect, it doesn't really matter. I've presented, these are my slides, and so this is my copyright. And so that part of the copyright is there. And what you copyright is also a little bit more technical, because it's not necessarily, it doesn't necessarily have to be the content. It can be how you organize the content, how you visually present the content, the colors that you use, the way that you do it. So that can be copyright as well. And I laugh because I know some of you are thinking, oh my gosh, how complicated can this possibly be? Well, you know, we're humans, right? And we tend to make things complicated. So over years and years and years, it's just become pretty complicated. We're doing very surface level explanations right now, just to kind of get everybody up to a certain level of expertise and knowledge, so that then if you need to jump off and go even deeper, you can, or maybe, you know, you're good right here. So that would be what my answer to the question is. The digital presentations are copywritten no matter what profession you're in. Okay, any other questions? I don't see any. So I'm going to go ahead and move on to trademarks. Trademarks are one thing that small businesses are very, very interested in, and more so than any other type of intellectual property I have found. So a trademark is a word or design that appears on goods or services to distinguish them from others in the market. They indicate the source of the goods or services and are intended to protect consumers. So let's talk about this definition for a minute, because there's a lot in here to unpack. So first of all, it's a word or design. Word or words, it doesn't have to be singular, it's word or words. It could just be the plain words themselves with nothing else, or it could be a design. The design may be just a design, or it may be a design with words. They have to appear on goods or services, and that distinguishes them from other goods and services in the marketplace. So what are we really talking about here? We're talking about branding. So trademarks are all about branding. It is the stamp that goes on to a product or a service that says, this is where it came from. And it is intended to indicate the source of the goods or service, again, where it comes from, and it's intended to protect consumers. So you have to understand where trademark law comes from. It is not meant to protect businesses. That is not the purpose of trademarks. It came about because it was intended to protect consumers. What we didn't want was consumers being deceived. Oh, you're buying a Nike shoes, but it didn't really come from Nike. It came from this other company. Well, that's consumer deception. And so that was what the law was meant to do. As business owners, we tend to think about it as protecting us. Like, we do this to protect us. And that's our motivation for doing a trademark or having a trademark. That's our motivation, but that is not the intent of the law. So you have to understand where the law is coming from so that you understand what the rules are and how it works. It is intended to protect consumers. So, what is a trademark? Let's dive in a little bit. I just talked about it's designed to protect consumers. So you have to understand it's not going to be necessarily business friendly. It's consumer friendly. And so that means that we are going to have to go through some hoops and do some things if we want this protection. So it's not set up to protect us. So therefore we have to do whatever we need to do to get the protection. So it could be a name, it could be a business name, which is very common. It could be a logo, business logo that's designed. Again, like I said, it could be a logo that has words in it. It could be a logo that doesn't have words in it. It could be a slogan, like a tagline, and then there could even be some branding images that are done. So I know, thinking of a couple of clients in the past who had little characters that they would use in their marketing, and the characters were part of their whole branding. So not only was their name and their logo trademarked, they had also trademarked these little characters, which was really cute. And a good idea because they created them and the characters fit into their business marketing plan. It identifies the source of the goods and services. We talked about that. And it distinguishes a business from others. So it distinguishes products from other businesses' products. Now, a lot of times people get copyright and trademark mixed up. So if you think about trademark, you are thinking about a brand. You're thinking about the brand of what is my identification mark. And if it helps to think about it this way, it came about way back in the day. Think about medieval times when you've got knights in suits of armor, and the people who made the armor had their own little stamp that they put in the branding. And you've got this on cattle ranches where you've got the little, the stamp or the brand that they put onto cattle to say that this cattle was raised on this farm, it came from this type of heritage, etc. It's that kind of branding. So it's to stamp the product, it's to stamp the services to say that this particular business did it. Now it benefits us because it promotes us as our business. It says, hey, if you like this quality, this is where it came from. And that, it spreads the word, it spreads the reputation, it spreads the quality, all of those things. And that's why we as business owners are so interested in having a trademark protection, because it does allow that to happen, that identity. And it keeps other people, other businesses from using our brand as theirs. So here's where it kicks in. So the benefits are it distinguishes a business from others. So in order to protect consumers, the law says you can't have two businesses with the same name that offer the same products, because now we're going to have consumer confusion. So if you think about from a business's perspective, we want that because we want to prevent other people from using our name. We want to prevent other people from using our logo or anything that we've created. So it does that as a secondary purpose. It helps us. And then it adds value to our business. So if we have trademarks, especially if we have registered trademarks, because they are so difficult to get, they add value to our business. So not only are they protecting our business, they are adding intrinsic value. So if we were to go and sell, this is what I hear, and we work with our clients a lot on this, is if, you know, if they're building it to sell, or if they're building the business, or if they're thinking about getting acquired by a bigger company, having those trademarks registered builds value inside the business and makes the business worth more, typically, as a general rule. So let's talk about what can and cannot be trademarked. You can't trademark someone else's name because it's their name and you can't prevent them from using their name. Generic names and words. So this is important because you don't want somebody to have the exclusive right to use a word that we all use. So I can't trademark law firm, because if I trademark law firm, then all the other law firms in the country have to stop using those words. That just doesn't make sense, right? So you can't have generic names and words. If I had a law firm in my business name and I wanted to trademark, say I wanted to trademark Lee Law Firm, I could do the whole thing, but I can't just keep law firm out of it. So I have to disclaim, what they call disclaim the law firm piece of it, in order to get it to go through. So there could be some generic names and words inside trademarks, but they have to be disclaimed and they can't be standalone. Descriptive words. So this comes into play where you think about why we have trademarks. Trademarks are to brand something, not describe something. So let's say you have a check cashing place that says Speedy Check Cashing. Well, that's not really a brand, is it? Because Speedy Check Cashing, anybody could say that. We do Speedy Check Cashing. That's not a distinctive brand that people are going to remember and say, oh, that's where I went for that. So it's very difficult to have the words Speedy Check Cashing trademarked because it's just describing your service. You know, if I had quality contract drafting, I can't trademark that because that's just describing what we do. That doesn't mean that, you know, quality contract drafting, you know, even if that were the name of my business, I couldn't go out and trademark that because that's a descriptive word. And then you can't trademark locations, you know, the name Jacksonville, any kind of cities, counties, states, any kind of offensive words, although that is here lately, the Supreme Court has made some rulings on some very interesting spin-offs of curse words. So if a curse word is spelled differently than, but pronounced the same, the Supreme Court has been saying that those are okay, whereas in the past those were not okay. So it's shifting a little bit on the offensive words. One thing I do want to say, I want to go back to this, is what can and cannot be trademarked. Federally, and we'll talk a little bit about this later, federally, things that are a federal crime cannot be trademarked. So marijuana usage is still considered a illegal substance in federal law. So federal trademarks are prohibited for marijuana related type of trademarks. So what are the different types of trademarks, which this is a good lead in for that. So number one, you have a common law trademark. So just like common law copyright, you have a common law trademark, which magically appears as soon as you open your doors for business. You have to open your doors. You have to offer something for sale in order to get it. And it's just a common law trademark, and you get it, but it's, again, very limited. It's only during the time that you are in business, and it's only in the geographic area where you are in business. So if you only do business in Jacksonville, if you do business throughout the entire, Duval County, then you could possibly have a common law trademark throughout Duval County. But if you only do business in, say, Springfield, you're not going to have a common law trademark out of Jacksonville Beach. So it's very much related to how you do business and where you do business. It's very, very specific to the facts of your case. And so common law trademarks can change. I mean, you can think about it, right? Say you have a business that, is a restaurant, and they started out in downtown Jacksonville, and now they've got, 20 locations throughout the county, throughout Duval County. Well, now their common law trademark has expanded. Well, now with certain times and, family members, retiring and new family members, not so whatever, now they've got down to 3, and now they're back down into like downtown area. Well, that common law trademark has shrunk too, because it's only where you do business when you do business. And so you can't have a common law trademark maybe where you want to expand. You have to go there, get set up first, and then your common law trademark comes. So you'll see the little TM here. That's what it means. It's like they are claiming a common law trademark. That means it has not been registered. Then you have a state trademark. So every state has trademark laws, and you can register for a trademark within a state. So back when I was a baby attorney, back in 2003, seems a long time ago now, I used to do Florida trademarks quite a bit, and it was appropriate at the time. And they're fairly simple, they're inexpensive, but they only cover you through the state of Florida. And then over time, more and more websites, more and more interstate, and people have websites that reach across state lines, country lines even. The state trademarks became less and less valuable. So while they are still available, people can still do a state trademark. It is less common to do them now, and it is less protection, obviously, because it only covers within Florida. And then you've got your federal trademark. And your federal trademarks are for the entire country. So when you do a federal trademark, it covers the entire 50 states. And this is what you see. Actually, that should be an R there. Looks like we have a typo on our slides. This should be an R. And it has a little circle around it, so federal trademark. And then you have an international trademark. An international trademark is you have to get the federal trademark first, and then you can go to other countries to do it. So we have a treaty with other countries that say, if we have a United States trademark, then we can get trademarks in other countries. That's called the Madrid Protocol, and there's things that you can do to do that. But for some small businesses, it's important to do, and adds great value to do internationally. All right, so for federally registered trademarks, so I'm gonna focus in on the one that people come to me the most for, and that is for the federal registration, the one that covers the entire country. So I'm going to talk about this one a little bit more in depth. And there's the application process for a federal trademark is horrendous. It is deceptively simple looking, and people don't understand how insanely complicated it really is. And what's happened is, and I'll tell you this just as, watch out for this, is I've had some businesses come to me after the fact, and they've gone online and they've done these super cheap kind of federal trademark. And some of them are really good. Some of them are really good. But they're only good for people who know what they're doing, because they're not lawyers and they're not going to tell you how to do it. So you have to input the information, and that's where it becomes critical. So I've had some businesses come to me and they've had some trademark issues, and they say, well, I've got this trademark, but they didn't input the data correctly. They didn't put the information on the application. So remember we talked about with patents, where you're like, I have a patent. And they came to me like, well, I have a trademark. But they thought they had the trademark to cover this much area, but the way they filled it out, it was only this much. So somebody else came into the market here, and there was nothing they could do about it, because they only had a trademark for here. They had only protected this. And so that's really where the pitfalls happen with trademarks, is because it seems like a pretty simple application. When you go through those online websites, but it's actually very complicated. If you were to go through the actual USPTO, that's the United States Patent and Trademark Office, if you were to go through their website and do the application from scratch, you would see how incredibly complicated it really is. So let's talk a little bit about kind of breaking down those complicated pieces. We talked about a word mark, that words can be trademarked. It can be 1 word, 2 words, 10 words. This is called a word mark, and it's just the words. It's not the font, it's not the size, it's not the color, it's just the words, and it's the plain words. This one, in my opinion, is the broadest one you can get, because no matter what color somebody puts it in, it's protected. No matter how somebody presents it in their logo, it's protected. So the words are the words are the words. No matter where they appear or how they appear, you can lock them down if you've got this on your trademark. So typically, we look at word mark. They are also the hardest to get because someone else might have those words in their design, in their logo. They might already have them filed. And so sometimes you can't get a word mark because someone else has already filed and has already taken that space. So I kind of think about it as a field. And, if you've got players on the field and you've got businesses as the players and you've got some players over here by the goal, but there's some over here and the other side of the field that aren't there, well, then you can put your players there. So it's very strategic as to how you position yourself in trademarks. So word marks run up against that difficulty. Design marks are a little bit easier to get because designs are typically unusual. They're creations, they're things that people have created. If they're simple, like just a circle, well then that's not so unusual, is it? That's not so unique. But designs have a tendency to be more unique than just words. And so sometimes they can be a little bit easier to get through the process. But again, designs have to be broken down by their elements. And so even a design is very difficult to do an application for because we have to code every shape. So the different circle, the different kinds of circles, if they're concentric circles, if they're all these different types of codes, numeric codes for each type of shape within that design. And then we've got codes for colors that we have to put in. So it can be, like I said, deceptively simple. So sometimes, getting that full, if you're going to go through this process, which is expensive, and it takes a long time. I tell people 12 to 18 months. I think the last time I looked, I still have some trademark applications pending that went in 19 months ago. And they're still pending, still going through the process. So it takes a long time to go through this. If you're going to do the expense and do the time, you need to submit the information on the application correctly, because once you go through this, you can't go back and change it. You have to start all over again if you want to do something different. So getting it right the first time is really important. The other thing you need to know is it's very industry specific. So if you think, I give this example, if you think about Dove, what do you think about when I say Dove? Do you think about the soap, the hand soap, or do you think about the chocolate? Either way, those are 2 different companies, right? Even though it's the exact same name, it's 2 different companies. So the consumer is not confused. I'm going to buy Dove soap. Oh, but I think I'm getting chocolate. That doesn't happen. So it's a little bit easier to understand that it's industry specific. Of course, we're going to allow people to sell soap under Dove because no one's going to get confused by that. So it's very industry specific when you go to file your trademark application and says, this is where I want to be. This is the industry I'm in. Any other industry can still use my name. So people are misunderstand when they say, I can prevent everybody in the world from using my business name. That's not the case. You can only prevent people who do what you do in your industry and who provide the products that you provide or the services that you provide. So describing what you do then is really important, isn't it? Because if you leave something out or you describe it wrong, then somebody else has the space to come in and do something similar to what you're doing because you didn't describe it well enough. You didn't, claim your area of the field well enough, and someone else can come in right next to you. There are 45 classes of goods and services. And so you have to pick one of the classes, maybe 2 classes, 3 classes, whatever it might be. But the classes are like the general industries. And then within the class are specific, so within each one of those classes, there's specific descriptions. And so within the descriptions then is where we start getting down into the nitty gritty. And so that's where the application process gets pretty complicated. And so federally registered trademarks are great to have if you can get through the process and understand what you're getting when you get it. So let's talk a little bit about common law trademarks. So this is the other kind of trademark that you get when you instantly have, as soon as you start using it, you get this protection instantly. So how do you protect it? You select your trademarks, keeping in mind what can and cannot be trademarked. It can't be names, it can't be locations, it can't be generic words. Business name, is it your business name stylized? Is it your logo? Is it your logo with business name? Is it your tagline? Is it your service line name? All these things are things that you need to think about when you're going to trademark. This is true whether you're going to do a common law, whether you're just going to rely on your common law trademark, or whether you're going to submit a federal trademark application. This is true. You need to select the trademarks that you want to use. And then how do you use them? And all of these have different pros and cons to them. I would say that starting with the business name obviously is pretty important, and logo is pretty important. And how you go from there then is dependent on your business, what your name is, what your logo looks like, and how you use it. So then the step 2 is immediately you can go ahead and start adding your common law trademark notice. And again, this is what it looks like, the TM. So the TM is a superscript, and you can put it on any common law trademark that you have. Keep in mind, it has to qualify as a trademark. You can't just go put TM on, you could, but it's not going to matter. You're going to put TM on every single thing. It has to actually be qualified as a trademark first before you can rely on that. So that you add it to the mark you selected and you use it everywhere. The consistency is what's important here, because what you want to do is every time you use it, you have the TM on it, and the consistency is important. It shows intent to protect that trademark. And then you can have multiple marks. So you can have multiple trademarks where you put the TM on them, and that's okay. All right, any questions so far? Do I have any questions on here that I want to? Okay, question is, do you have to put the C with the circle for the copyright on every page of a presentation, for example? And similarly, would the TM have to be shown every time a logo is shown? I would say the more you use it, the stronger your rights are. So if you just use it once and you don't typically use it consistently, then the argument could be, well, you really weren't serious about it, and we didn't see the copy that had the notice on it. We saw this copy over here that didn't have the notice on it, so we didn't know it was copyrighted, or we didn't know it was trademarked. So the stronger argument, the better business practice is to use it every time. Now, whether you have to use it on every single page of your presentation, you could. You can see on my presentation, I don't have it on every single slide. So, it depends on the whole, the whole piece has it versus each individual part of the whole is your call. I think it's visually determining how you want your presentation to look visually. It certainly can't hurt to put it at the bottom. And sometimes, depending on the circumstances, I do put it on every single page. If I'm concerned about something, I would do that. For this, I'm not as concerned about. So, all right. Next question, how can one determine if a mark qualifies as a common law trademark before it can be used? Okay, that's a good question. So let me go back a couple of slides here. So this is where you're going to look first, and you're going to say, which one of these do I want to do? And that's going to be where you're going to start. You're going to say, you know, which one do I determine, do I want to use as a trademark? And then what you're going to do is you're going to go back to this. You're going to make sure that it's not a name. You're going to make sure that it's not generic. And you're going to make sure it doesn't have descriptive words and locations or offensive words. Other than that, it's fair game. So you just want to make sure that it's not one of those things, and then it can be, it's a good chance that. Now, keep in mind, if someone else already has the trademark on it, you could get yourself into some trouble, because if they have a federal trademark, that means that's over the whole entire country. So you probably want to make sure that someone else doesn't already have that trademark. That's honestly, that's hard to do. I mean, there are some search services online that are fairly reliable that you can use to do a quick search, but just make sure it's a trademark search and not a name search, because that's a little bit different. A trademark search will go in and make sure who has a registered trademark already. So I have had some clients in the past that have come to me after they've set up their business and they've got their signage and they've got everything up and everything's great. And then they get this letter from some attorney that says, oh, you must cease and desist the use of your business name because my client already has the trademark on it. And then, their eyes get big. Oh my God, what did I do? Like, what's going on here? And of course they come in and we say, okay, well, what do they have? And we do all the research. And many times I have to say, they're right. The other company has this trademark already and you can't use it. And you've got to change your business name. And that's expensive. They had to change their signage. They had to change all their business cards. They had to change their website, everything. Because that other company already had that trademark. So I think before you use yours, you do all those things. You make sure that you've searched and no one else has it or has rights to it, that it qualifies as a trademark. And then it's one of those things, your business name, one of these things. And then you can proceed with it. Good questions. All right, I'm open for some others. I'm going to go ahead and continue my conversation and presentation, but I'm open to some of these trademark questions because these are the exact same questions that I get on a regular basis. It is one of those things that people are very interested in. I will say that there's these myths that go around and there's all these conversations about, well, you've got to do this or you've got to do that, that business owners kind of talk amongst each other. And I'm not convinced that every business needs a trademark, a registered trademark. I'm not convinced of that. I think that some businesses never need to register for a trademark. I think that some businesses would be better served registering for a federal trademark, for sure. And a lot of that determination depends on what you're going to do with the business. What is your plans for the business? What are the products or services that you offer? How important is it that you have that brand protected? How unique is your name? How unique is your logo? How much do you love it? All of those things, because it is expensive to do a federal trademark. To do it right. Again, it's not as expensive to go online and do one of those cheapy online things. But again, you get what you pay for, and they rely on you to know what to put in. You know, they're not counseling you or doing any strategy or anything like that. It's just basically an interface that makes it easier for you to input your data, and then they submit it. So, so if you do it the right way, it is expensive. It's an investment in your business, and it's a long period of time to wait. All right, so where was I? Let's go back to where we were on our slides. Common law trademark notice, superscript. Okay, so frequently asked questions. So this is some of the things that I've collected over the years of people asking me. What do I, or who do I call if someone tries to use my common law trademark? I'm going to modify this actually, and I'm going to say, who do I call if someone tries to use any of my trademarks? My federal trademark, my registered trademark, my state trademark, any trademark you have. Who do you call if you find out that someone else is using your trademark? There's nobody to call. It is, the government doesn't police it. There's no reporting. You know, the sheriff's department, police department doesn't do anything. That's not their jurisdiction. The government is not going to do anything for trademark infringement. It is a complete self-enforcement mechanism. So you are responsible for enforcing your own trademark rights, which means you have to go out and hire a lawyer to send a cease and desist letter saying, stop using this. And you have to pay your lawyer to prosecute the other party if they don't stop. In other words, file a lawsuit, take them to court, sue them for infringement, copyright infringement, trademark infringement, patent infringement. It's all the same. It's all self-enforcement, which means the government's not going to do anything. You have to have the ability to enforce it yourself. Otherwise, you lose the right to enforce it. You can lose the right to enforce it. So if you see people out there using your stuff, using your intellectual property, and you do nothing, you are basically saying, I no longer claim ownership of that, because you're not enforcing your rights. You're not preventing people from doing it. So the law says, well, it must not be as important to you. So if you're not going to enforce your rights, you know, you can't come back 5 years from now and say, well, this person was doing it. I let these other 10 people do it, but this person I care about. I don't want this person to do it. You have to enforce it against everybody. Otherwise, the courts are not going to take you seriously, and they're not going to say, and the other party can argue, look, you've lost your right to enforce it. So that's important to understand when you go through the process of filing a trademark. You know, you have to be willing to protect it and do the steps that need to be taken if someone does infringe. Next question. What is the difference between a trademark and a fictitious name? A fictitious name sometimes is called a DBA, doing business as. This is a very common mix-up. So a fictitious name, which we talked about our very first class if you were with me, only connects the business name to the entity. So, you know, if you have like a business name that says, you know, John's Lawn Service, and your company is, you know, John Lennon and Yoko LLC. So, you know, John's Lawn Service is going to be the fictitious name. It connects the name that you've got on your signs to the actual entity name. That has nothing to do with trademarks. So fictitious names is a state thing. So the state takes the fictitious name registrations, and they'll take whatever you file. You can go on Sunbiz right now and pull up a fictitious name search, pick anything. There might be 5 of them registered. The state doesn't care. The state will take as many as get filed as they want to file. It is merely a notice requirement. So if someone sees John's Lawn Service drive by and they're like, that guy just hit a dog, and they want to find out who John's Lawn Service is, they go in, they type in John's Lawn Service, and up comes John Lennon and Yoko LLC. So then they know who to go after. That's not a trademark. You know, a trademark is the brand. And so that's a completely different filing. It's a completely different system. It's not even at all related to a fictitious name. So people who file a fictitious name and think they have a trademark do not. They are not protected. And then my last commonly asked question is, what is the difference between a trademark and a domain name? So people say often to me, well, I got the domain. I bought the URL. I've got that. And so now I'm protected. Again, completely different system. It is not even at all related. If you have the domain name, and I've actually had this happen to some clients, they bought the domain name, but someone else owned the trademark. They had to sell the domain name because they could never use it. Because someone else owned the trademark, they had the right to that name in the marketplace. So if my client started using that domain, they would infringe upon that other person's trademark rights. So they bought it and could never use it because it was someone else's trademark. It's a completely different system. Just because you bought the URL or the domain name does not mean that you have protection for that. So those are different systems, and keeping those separate and understanding how they each work is important. Okay, let me just check and see, do we have any other questions that have popped up since I've been doing my FAQ? Okay, none so far. So we're running out of time here. I'm gonna open it up to questions for anything in just a second. I will tell you your audit sheet is coming. It's in the for intellectual property. It is in your virtual, and I don't have a copy of it, so I'm going to pull it up real quick here. If you can see this audit sheet, somebody type in the chat for me that you can see the audit sheet because I switched my screen. Okay, very good. So this is the audit sheet you'll get for intellectual property. It'll have some questions about internal copyrights. Remember what you create for your own business. And then your external copyrights, what you create for others outside of your business. And then some licensing issues about, you know, trying to spot maybe where you might have some copyright licenses that you didn't realize. And then there's some trademark questions. It is not a big audit sheet, and it does not have anything about patents. The reason it doesn't have anything about patents is because they're too complicated for me to even come up with general questions. They are too complicated. There's too many types of patents with too many different variables for me to come up with questions that would flag something for you. So if you think you have a patent issue, my recommendation and advice would be to find a patent attorney and sit down with them and discuss it to see what you may have. Again, timing is critical on the patents. But as far as copyrights and trademarks, this is what your audit sheet will look like inside your virtual classroom. Okay, so let's go back to then the whole class, the whole month we've been together, all 4 weeks, 4 classes, all of these different topics. I want you to pull out your audit sheets, take a look at all of them, and put them in order. Put the one on top that has the most pressing issues, the ones that you worry about the most, and then the second, third, and fourth, and so forth. Order them in a way that shows you where you think you need to start taking care of some of these things that we've been discussing. And then just keep it in a folder and start working on it. Again, like I said, consistent steps on a regular basis will get you so much farther than you think. It is better than ignoring it. It is better than pretending it doesn't exist and hoping it goes away and the problems don't ever come up. So the point of the class is to be aware of it, do your assessments, and then prioritize how you're going to spend your next month, 2 months, how much ever time you're giving yourself. And remember, I've always been saying, put it on your calendar about what you need to do and when you need to do it. Last opportunity for Q&A. I don't see anything here. Jackie, did you see anything come up before I finalize?
I don't see any questions in the Q&A function. As Lori's mentioned, we'll be here for the next couple of minutes. Allow this time to ask her live questions. We'll also have Lori's contact information on that online classroom. I shared the link in the chat. You'll also get a feedback form after today's session ends, so please take the time filling those out. Those of you who have been filling them out, thank you very much. It helps us at the Women's Business Center understand the needs of this class and workshop series, and it's going to help Lori as well understand, how she can help best assess our needs of our business owners. So thank you all.
Yeah, and I have one more thing, Jackie. There was one other thing in the virtual room, if I have a minute to do. If you all would like to go to, this is our website, thelegaldepartment.law. First of all, we have a lot of blog articles and resources on there for you if you'd like those. If you go to door number 4, that is a program that we offer for small businesses that you might find interesting. We are offering a webinar. Let me pull up that real quick. This is in your virtual classroom, and it has this door number 4 website on it. We offer a free webinar if you want to take a look at that to see if door number 4 is a program that you want. What it is it's a monthly thing where we meet and actually go through all of those areas of the infrastructure map that we covered, but we go into detail, and we have, somebody had asked me about templates, and we give out templates, and we give out checklists, and we give out all kinds of info sheets and resources every month, depending on what we do. So one of the things that we covered in door number 4 was our common law copyrights. So we spent 1 month going through our copyrights, our trademarks, common law trademarks, going through them, figuring out which ones we wanted to put the TMs on and go through that, and had some templates and things for that. So those are the kinds of things that we do, and that website right there has some other types of topics. And if you want to sign up for that webinar, feel free to do that, and it explains I'll explain the door number 4 program a little bit more in depth. But if you're interested in continuing something like this, just more detailed, that would be door number 4.
Awesome, thank you. Yes, as mentioned, we included that on the online classroom, so you can download that flyer, highlight the link if you need to copy that. And with that, if I don't see any more questions, we'll adjourn today's meeting. Lori, thank you very, very much.
My pleasure.
For everything.
I love going over this stuff. I hope it was beneficial for you all.
Take care, everybody. Have a great rest of your day. Happy Veterans Day to all of those out there as well.